Welcome, everyone. My name is Arif Jamal, and I'm the Deputy Director of the Center for Asian Legal Studies, or CALS, at the National University of Singapore Faculty of Law, and a co-convener along with my colleague, Dr. Dian Shah, who you will meet shortly, of the CALS Law and Religion Cluster. The Law and Religion Cluster is interested in religious law, state-religion relations, and the regulation of religion and dealing with religious freedom. The cluster embraces a contextual and multidisciplinary approach to try to understand the dynamics between law and religion. To this end, the Law and Religion Cluster has organized a series of activities in the past, including distinguished lectures, the last being by Professor Abdullah Naim from Emory University, academic conferences, out of one of which last year a book entitled Regulating Religion in Asia was published by Cambridge University Press, and of course, the Law and Religion Speaker Series in which you are participating today. The speaker series are normally held in person, but we are grateful to have Dr. Nurfadzilah Yahaya and all of you today for the first virtual speaker series session. Thank you, Fazila, and welcome to you all. Let me now hand over to Dian Shah, who is moderating today's session for the proper introductions. Dian.
Thank you, Arif. Good afternoon, everyone, and good morning, good evening to all of those of you who are joining us from the UK, US, Europe, India, and anywhere else in the world. So let me first echo Arif in thanking Fazila for accepting our invitation for the speaker series, and also to all of you for joining us. We have a couple more exciting speakers scheduled for this series throughout the rest of the year, so please keep an eye out for our announcements in due course. But our speaker, over to our speaker today, Dr. Nurfadzilah Yahaya. She actually needs no introduction, but I'll introduce her anyway. She's an assistant professor of history at NUS. She's a legal historian, graduated with a PhD in history from Princeton University in 2012. And she was previously a postdoctoral fellow in Islamic studies in Washington University at St. Louis. Now today, Fazilah's presentation will draw on her upcoming book, published by Cornell University Press, entitled Fluid Jurisdictions, Colonial Law and Arabs in South Asia. So we are essentially getting a sneak peek here of the book today, which will be available for purchase in September 2020, so in a few months. So be sure to get a copy, but this is not a paid or planned advertisement, by the way. I just got excited reading the abstract, so I'm gonna buy one. Without further ado now, Fazila, over to you.
Thank you, Dian and Arif, for inviting me to speak today. My book is a story of legal jurisdictional puzzles, which is very much a feature of colonialism from the late 19th century onwards, as legal jurisdictions became hugely complicated. What is unusual about the story of the Arab diaspora in Southeast Asia is that despite being a very small minority in the region, at less than 0.1% in the British Strait settlements, which include Singapore, Malacca, and Penang, and an average of 6% in the Netherlands Indies, they were able to influence the shape of law, especially Islamic law, to a great extent. Despite not entering the ranks of legal practitioners in a big way, unlike, for example, the Parsis in British India, as we see in the work of Mitra Sharafi, they certainly played an outsized role in the development of law in the colony. The story of the Arab diaspora in Southeast Asia was a story of projection of legal authority over colonial subjects by colonial subjects. They continually operated in a global field, as my talk today will demonstrate. In the Netherlands Indies, colonial subject population was triated according to ethnicity. The vast majority of subject populations were natives or inlanders in Dutch, while Arabs, Chinese, and Japanese were foreign Orientals, or Vreemde Oosterlingen in Dutch. The ethnic classification of Arabs applied to all whom the Dutch identified as such, although most Arabs by the late 19th century were of mixed origin, cultural heritage, and biological lineage. They were classified as such by the Dutch. This is a population table which I reproduced in my book. Arabs comprise 5 to 7% of the population in the Netherlands Indies, depending on the location in the archipelago. Most foreign Orientals were Chinese, followed by the Arabs, and then the Japanese. The headline of a report in 1934 read, Arab or native, or rather question of nationality, Arab or native. It touches upon the legal case of guardianship over a boy. And this legal case encapsulates the absurdity of legal separations within the Dutch colony in the 20th century. The boy in question was half Dutch, half Arab, living in Meester Cornelis, now known as Jati Negara, in East Java, with his Arab guardian appointed by his father prior to the case. His biological father was Arab, and he had returned to Hadramaut in Arabia, where he came from. The boy's mother had passed away. The case embodied the legal complexities wrought by a system predicated on difference, separation, and pluralism, rather than actual reality on the ground. It is telling that neither the Dutch reporter who wrote this article, nor the judge, who was also Dutch, ever considered the boy might be European, although his mother was Dutch. Out of the three groups, Europeans, foreign Orientals, and natives, foreign Orientals ended up being the most disadvantaged by the early 20th century. Foreign Orientals were made to pay higher taxes by Dutch colonial authorities. They couldn't own most kinds of landed property, and they had to attend specific schools. They also had to live in designated quarters, prevented from traveling, and subjected to more policing and surveillance than natives even. Dutch authorities enforced dressing codes for each community based on what they thought each community wore in the country of origin. While restrictions for Chinese foreign Orientals were lifted from 1910 to 1915, restrictions on Arab mobility remained in place for decades afterwards, right up till Japanese occupation. It's not surprising, therefore, that these Arab foreign Orientals tried to transition into another group, be it the natives or Europeans. They made moves in both directions, and they were able to adopt a variety of legal strategies according to their circumstances. Many Arabs could pass as either or both, since a large number were, as I mentioned before, of mixed descent by the time they arrived in Southeast Asia. But this passing could only occur on the sly, illicitly. Scouring colonial law reports, I discover moments of innovative legal choices which ran the whole gamut of options, from active collusion with colonial officials, passive co-optation by them, and claims to extraterritoriality, which I will focus on today. From 1870s onwards, several Arab foreign Orientals tried to claim European status through identifying as part of the Ottoman Empire, since the heart of the empire, Istanbul, was in Europe, and it was recognized by the Dutch to be located in Europe. What these Arabs were actually asking for was to be recognized as Europeans under the rubric of Dutch colonialism. They did so by proclaiming ties of loyalty to their land of origin, Hadramaut, which you can see on this slide here, over here, which is located in present-day Yemen. In other words, They situated their identity and lives outside of Netherlands Indies, out of Southeast Asia altogether, across the Indian Ocean, in keeping with the term, classification, the label foisted upon them by the Dutch, which is foreign Orientals. European status was highly desirable to these Arabs, who were acutely aware of the inferior status that the classification of foreign Orientals conferred on them. By appealing to Ottoman subjecthood, these Arabs were in fact pursuing extraterritoriality, which is a specific legal term that is essentially an exemption from local law. At this time, that would be colonial law being applied to them. The request was unusual for colonial subjects because colonial subjects were normally denied extraterritorial jurisdictions. In fact, that's what it means to be a colonial subject. You are being subjugated. While extraterritorial arrangements found in Japan, China, and throughout the Ottoman Empire in the 19th and 20th centuries are well documented by historians, aspirations by subject populations in colonies for the status of exemption from the law of the land have not been investigated. Although historian Lisa Ford points out how Aboriginal populations in New South Wales were exempted from settler law for a time in an anomalous arrangement in territory that had been declared terra nullius. So it's very different from the colonies that I look at in my book, the British Strait Settlements and the Netherlands Indies, because neither terra nullius was not declared in either jurisdiction. In the colonies, the very fact that one was a colonial subject meant that one was in a subordinate position, not on par with colonial powers. So extraterritoriality was not likely to be an attainable goal by colonial subjects anywhere in the world. Legal parity in the courtroom was not possible under any circumstance because the application of different laws to foreign Orientals in the Netherlands Indies stemmed from a lack of trust that had to be mitigated by extra precautionary measures not applied to agreements with native populations. So there was a reason for them to be separated from native populations in censuses and according to law by the Dutch. And this is what I explored in my book. That being said, in many ways, extraterritoriality is quintessential legal imperialism. It is often granted to Europeans, as we see in Shanghai, Hong Kong, and Istanbul during the same period. Any kind of legal exemptions under colonial rule is dispensed via exceptions doled out by the colonial powers themselves. An Arab merchant, originally from Baghdad, residing in Batavia, which is now of course Jakarta, in 1871, attempted to claim equal status with Europeans just by referring to a treaty between the Netherlands and Istanbul sometime in the past. Although legal courts in Batavia, Dutch legal courts, were quick to ascertain that the merchant was mistaken, so he wasn't granted exemption. In the 1880s, several Arabs in Batavia also claimed European status after pledging their allegiance to the Ottoman Sultan, despite having never even lived in Hadramaut. It was reported in Dutch newspapers that Arabs in the Netherlands Indies even produced certificates declaring European origin. And these certificates were produced by the Ottomans for these Arabs in the Netherlands Indies. In 1907, the identity of a man named Saleh Fageh presented a challenge to Dutch authorities, and it was reported in the Dutch newspapers over several days. He was born in Makkah to parents who were Turks from Albania, with a grandfather who was identified as Roman Catholic, though all his other family members were Muslims. Dutch authorities did not know how to classify him and kept on asking each other for opinions. Eventually, he was classified as Arab Turk and momentarily grouped with the foreign Orientals, who happened to be his fellow litigants in this particular legal case. in which he appeared in court for. He appealed this ruling, and the Supreme Court in Batavia subsequently declared him a European. The case was then brought to the Raad van Justitie in Bandung, rather than to the Landraad, which is a lower court, meant only for natives and foreign orientals, including Arabs. So this is why they were so concerned. This is why colonial subjects and the Dutch were all very concerned about who's who, because it determines what court you could appear in and could judge your case. The Appellate Judicial Council, of which there were 6 throughout the Netherlands Indies, was, for example, reserved only for Europeans, and occasionally heard appeals from natives and foreign orientals if the cases involving them also involved Europeans. The Supreme Court in Batavia, which had jurisdiction over the entire Netherlands Indies, formed the only tether to the seat of Dutch political authority for the other courts elsewhere throughout the archipelago. Its jurisdiction extended to all civil and commercial disputes within the European community, including criminal acts committed by Europeans. I saw numerous instances of courts declaring themselves incompetent whenever cases involving Arabs appeared on their dockets. It was incredibly frustrating to be a foreign oriental, an actual category in censuses, but a liminal category in legal courts. So they were neither Europeans nor natives, and it was very difficult for the courts to decide where they belong, and often declared themselves incompetent, and the case would just be dropped. Overall, the claim of Ottoman subjecthood among Arabs in the Netherlands Indies was weak when you look at it from all angles. Most Arabs in the Netherlands Indies were, of course, not from Baghdad or Turkey in the Ottoman Empire proper, one might say, for lack of a better word, but from the fringes, from Hadramaut, where Ottoman hold was tenuous, and some would argue there was no hold over Hadramaut by the Ottomans. Although, in 1872, the Ottoman Sultan did install a governor for the Hadrami coast. The Ottoman consul in Singapore since 1864 also tended to be Hadrami, one after another. So here we have a map of Hadramaut. To complicate matters, although Dutch authorities in Batavia refused to recognize these claims of Ottoman subjecthood, they themselves vested Ottoman authority with a legal hold over Arabs of Hadrami descent based in the Netherlands Indies, but only with regards to their property in Hadramaut. So it's extremely confusing because on one hand they were like, you're not Ottoman subjects. But then when it comes to cases involving property in Hadramaut, which appeared in Dutch courts in the Netherlands Indies, they were like, oh, now we have to refer you to Ottoman authorities and let them judge whatever, you know. So this was the arrangement since 1881. Sometime in the 1880s, the Dutch government went further to institute that legal documents, such as powers of attorney, not only had to be approved by Qadis in Hadramaut, but also to be ratified by the Ottoman consul in Batavia. Already robbed of their diplomatic status amid strained relations between Dutch and Ottoman authorities during this time, the Ottoman consuls, when there was a succession of them, now had to suffer the indignity of verifying the authenticity of seals and signatures on documents that originated in Hadramaut. This requirement, not surprisingly, met with several complaints from members of the Arab community, who argued that it was ridiculous to expect the Ottoman consul to have knowledge of Hadramaut and the Netherlands Indies, because neither Hadramaut nor the Netherlands Indies was, legally speaking, Ottoman territory. Rather absurdly, the Ottoman consul often had to consult the Arabs themselves, since he had no way of verifying anything by himself. Worse, there was a hefty fee for the Ottoman consul's legal services, between 40 and 50 guilders, an amount often worth more than the real estate property in question. Because the legal system in the Netherlands Indies was highly localized, documents deemed valid in Batavia were not automatically regarded as valid elsewhere in the colony, say in Surabaya. This Kafkaesque jurisdictional situation led to inconsistency that could be exploited by colonial subjects to continually negotiate their status. This is what they did till the end of the colonial period. There was a lot of uncertainty, but there was also quite a bit of room to maneuver in the midst of colonial oppression because of confusion and chaos which could be exploited. Arab subjects were not out of bounds in appealing to Ottoman loyalty from the perspective of colonial classification which the Dutch established. Laws that pertained to foreign Orientals sometimes verged on mimicking international law. In a way, the category of foreign Orientals emerged as a form of quasi-sovereignty, albeit under colonial rule. The differentiation of colonial populations into three sections, natives, foreign Orientals, and Europeans, gave rise to quasi-international Privatrecht, where each legal system meant for each group was attributed fictional territorial jurisdiction. The phenomenon fits what Lauren Benton describes as the emerging model of an international legal community composed of polities recognized as civilized by the societies already considered members of the international community during the 19th century. The fact that international law, glossed by the Dutch as intergentil recht, was invoked in cases involving natives, foreign Orientals, and or Europeans from 1887 onwards, meant that a conflict of laws was inherent in every case involving parties in different colonial categories. This system is incongruous, since international law could actually only be applied between nations. It certainly did not reach within states, because that would violate a state sovereignty. Moreover, the application of international law assumes that there were identifiable nations within the colony. On a superficial level, it flattered the Dutch colonial government to conceive of the population of the Netherlands Indies as a territorially compact people, rather than the sprawling and stratified colony that it was. Jennifer Pitts rightly claims that the law of nations discourse obscures the imperial nature of European states to an actual colony. And here we see a hyper version of this. An optimistic teleology would be that this international system, however orchestrated and fake it seems, was the harbinger of the complete system that would someday emerge. It is easy, therefore, to imagine how some of the Arab elite were inspired to achieve actual quasi-sovereignty, a term that refers to the status of sub-polities within empire states that were said to retain some measure of authority over their internal legal affairs, while holding only limited capacity to form international relations. As I examine in my book, the attempt by the Arab elite in the Netherlands Indies to appeal to Ottoman protection as subjects potentially led to a paradigm of diplomacy in the colony that inadvertently allowed some colonial subjects more latitude than the Dutch colonialists intended for them. The appeal to Ottoman subjecthood is just one of many strategies pursued by the Arab diaspora in Southeast Asia. In my book, I demonstrate yet other Arab contributions to legal development in the colonies that were far more extensive and permanent. I begin by tracing how authorship of legal codes is bound up in questions of discovery, power, and authorship. Assessing how and why certain voices or frameworks were elevated and others disregarded reveals the profoundly asymmetric power dynamics within the Muslim communities themselves. In the realm of Islamic law, colonial officials became the authors as they determined the law. In the realm, to some extent, the Arab elite were the co-authors in Southeast Asia. I explore the limits of this co-authorship. As I have written elsewhere and further explore in my book, the main critical tenet of contestation with regards to Islamic law among the Arab male elite was neither theological nor intellectual. For them, the primary impetus for more colonial involvement was actually local Qadi's approval of wife-initiated divorce cases and the problem of choice of marriage partners by Arab women. At times, the new repertoire of legal options transmitted across the Indian Ocean and within Southeast Asia garnered an appearance of neutrality that disguised unequal colonial power structures. Perhaps the gradualness of the process of legal change allowed this to happen, or makes it seem this way. Undoubtedly, a new age of legal pluralism had dawned and enabled some colonial subjects to weaponize this legal pluralism even against members of their own communities. Subject populations in the British Strait settlements were organized in censuses according to religion. So it's quite different from the Netherlands Indies. The Arab community managed to distinguish themselves, especially after the colony became a crown colony in 1867, such that they managed to get British authorities to do what they wanted in the closing decades of the 19th century. Arabs fared far better in the British Strait settlements overall than in the Netherlands Indies. They were very successful in getting control, at least in the beginning, by convincing the British to enact the Muhammadan Marriage Ordinance in 1880. They had a keen sense of colonial contingencies, bolstered by their identity as a mobile diaspora. And in that sense, they had something in common with the British, supposedly. Fittingly, a BBC Arabic transmission in 1939, on the eve of World War II, described Arabs in Southeast Asia as, and I quote, patriotic to their country of origin and law-abiding to their country of adoption. One can definitely see how British authorities perceive this to be true. In this slide, for example, we see the census placed alongside the contributions to wartime subscriptions in the year 1915. And this occurred just after the Sepoy Mutiny in Singapore. The Arabs took the helm of control and over the Muslim community and pledged their loyalty to the British in order to mitigate the harm that they perceived had been done due to the Sepoy Mutiny in February 1915 by the Sepoys in Singapore against the British. So over here we see that the Europeans and Eurasians they include British officials, colonial officials, who donated in their private capacity to wartime contributions, to wartime funds. The Malays, Chinese, and Indians were colonial subjects. Japanese, Arabs, and Jews were also colonial subjects, but in terms of class, they were usually profiled as wealthy merchants, more civilized and such. The Jewish population were the wealthiest sector in Singapore at this time, followed by the Arabs. Yeah. So I will stop sharing my slides at this point as I wrap up. In keeping with anthropologist Brinkley Messick's hatful schema, described in his book, Sharia Scripts, I argue that the Arab diaspora in Southeast Asia contributed to creating a legal archive, but did not contribute to dominate the library. The library and the archive indicate the separate yet interdependent textual realms that occupy different discursive modalities within an overarching juridical culture encompassing the book and the document respectively. The book associated with the library and the document associated with the archive. The contributions of the Arab elite in shaping Islamic law in the Straits settlements would play out through litigation, because the results of their legal cases eventually became legal precedents cited even today, not just in Singapore, but also in Malaysia. Arab litigants managed to change law over several decades in a limited fashion only by establishing legal precedent in the English common law tradition. In both colonies, Arabs generally wanted to restrict the interpretive communities to themselves and their allies, including European colonial officials, which is an uncomfortable truth. They were successful towards the end of the 19th century, and I would say even in the early 20th century. Being colonial subjects, however, they were subsequently quite easily sidelined by colonial officials. The enactment of Islamic law was contingent on power dynamics in the relationships between the Muslim elite and colonialists. The contingency is evident in the ways that colonial authorities engaged and responded to Muslims throughout their colonies. As the Arab diaspora rooted their lives and property more and more in Southeast Asia, they shifted their legal strategies. The mercantile elite became quite wealthy and became very anxious to preserve their wealth. And this was a main motivation for them in determining their actions and a huge factor in the choices that they made. The institution of the religious endowment, known as Waqf, W-A-Q-F, or W-A-K-F in Malay, which I examined in the last chapter of my book, embodied this legal anxiety, which led to much legal creativity and change that emerged during this colonial period. Waqfs enabled members of the Arab diaspora to preserve their families' prosperity and social capital in the British Straits settlements, where Arab investment was very high, especially in Singapore, and where such endowments were not banned, unlike in the Netherlands Indies, where such waqfs exist, but only on the sly, because officially they were not allowed to exist. To ensure their wealth remained in their families for generations, they coded their property legally as a type of religious endowment known as waqf, thus insulating their assets from tax authorities and disintegration, further enhancing their durability, the durability of their assets. In the eyes of colonial authorities, the waqf was essentially a trust, a form of preemptive asset shielding. But this popular strategy came at a high price. In common law jurisdictions, private family waqfs were not allowed to exist forever, a requirement in Islamic law. Due to the English law against perpetuities, which states that no interest is good unless it must vest, if at all, no later than 21 years after some life in being at the creation of the trust. So they have to expire after 21 years after the death of the last living relative when the waqf was created. In order for waqfs to be charitable, because charitable waqfs could exist forever, so there is an out, they had to be public. That is, certainly meant for people beyond one's family. A purpose was not charitable unless it was for public benefit, although British authorities recognized that the Muslim definition was different. In contrast, family endowments benefited only a relatively small, select group of people. For instance, members of a particular family or clan, instead of the general, more abstract public. In Straits settlements courts, the understanding of the term family was at odds with Arab understanding, which include a wider category of people linked to the testator by slavery, marriage, service, or blood. Arab conceptions of family were more akin to households, which would include servants as well. Also, as a diaspora, their orbit of responsibility simply expanded through travel. Hence, Arab testators potentially included their entire clan located throughout the Indian Ocean as family. If we were to look at lateral relatives through this lens, the picture would look entirely different. But the judges in Strait Settlement Courts only prioritize vertical descendants. At the core of my book is the question of jurisdictions, which my historical actors navigated. By jurisdictions, I do not mean just territorial jurisdictions, but also jurisdictions of prescribed legal spheres that emerged under colonial rule, secular versus religious being the most prominent binary across the world. This binary has fortunately been complicated by many scholars. Cases involving waqfs presented the supreme challenge to colonial separation of economic and religious spheres of life. Personal law was the purview of religious law and vice versa, normally throughout the world in European colonies. In waqf cases, personal law, religious law, contract law, and property law were constantly entangled. Waqfs perform a radically different set of functions during the colonial period than they do now. Now, of course, we have the government to provide welfare services. Back then, during the colonial period, colonial subjects were left on their own to fend for themselves besides basic subsistence. So medical care, religious services such as mosques, cemeteries, schools, and even food distribution were historically provided for by Muslim elite in the colonies to a great extent. So there was a lot more dependence on waqfs in the past than there is now. An archive is a private life displaced to a public space, in the words of writer Leslie Jamieson. My historical actors allowed European colonial officials to regulate their intimate lives, which is remarkable. Their motivation was tied to their mobility and wealth. Their property and family relations eventually rooted them in specific jurisdictions in Southeast Asia. We know that now. As I make it a point to remain committed to their perspective, I discover that they were navigating complex terrains in constant formation. Nothing was fixed for them at the time, so they held out hope that they could influence the shape of things. They inhabited very busy worlds in multiple languages simultaneously. Arabic, Malay, and other languages of the archipelago, as well as English, Dutch, and French, the language of the Napoleonic Code, which formed the basis of Dutch civil law. In reading and interpreting my archival sources, I discern a world always in complex movement that resisted all abstract categories, including Islamic law. Even in the midst of oppression, there was much room for legal maneuver when it came to Islamic law in the colonies in unexpected ways. Collectively, the Arab elite's usage of powers of attorney, calling upon colonial legal channels to administer Islamic law, and their avid establishment of property waqfs in the colonies rooted colonial law more firmly in Southeast Asia. They had a vision of how law, including Islamic law, which they had some control over, so they certainly tried to craft legal codes and influence religious practice in their own vision. Most importantly, the wealthy Arab elite harnessed colonial legal resources to manage their wealth across the Indian Ocean via powers of attorney infused with new British and Dutch legal idioms, but still operated within a familiar procedural framework, which took place over centuries in the Islamic world based on contract law. They were very much concerned with ownership and record keeping, which led them to appreciate the importance of the instrumentality of registration and entering into probate. By surrendering to the thrall of state authority, which in this period was colonial authority, they ended up reaching for something beyond their control. Thank you.
Thank you, Fazila. I think it's interesting how your research, in your research, these issues of class, classification, identity, and status, they sort of linger. And these issues are, of course, still significant today, and if I might say, magnified by this COVID-19 situation. And the other interesting point that I caught from your presentation was about legal pluralism, particularly as a result of the role of Arab litigants in shaping the content of Islamic law in this region. Thank you very much, Fazilah, for sharing.
Thank you. Thank you very much.
And your really fascinating book. Again, as she said, it's available to ship from August 15, so get your copy soon. Thank you everyone for joining us. And from wherever you are now, you can go for breakfast or go back to sleep or go for lunch. Stay tuned for our next speaker series. We will have one maybe in about 2 months from now. And do check out our Facebook page, CAL's Facebook page, for more information. So have a good day, everyone. Thank you very much for joining us.
Thank you so much.